Hello everyone. The next HR topic for this information session is around considering your legal obligations before you hire. My name's Mary. I'm a HR professional with 20 years experience in the HR industry across a range of businesses from small businesses, not-for-profits, local government and larger corporate organisations. So in today's discussion we're going to talk about the Fair Work requirements, employment types and legal distinctions, key employment documents, workplace HR policies and procedures, tax and superannuation requirements. So first of all, Fair Work requirements. So what legislative information do you need to provide to employees? The only requirement at the time of providing an employment contract or offer of employment is a copy of the Fair Work Ombudsman's National Employment Standard, so otherwise known as the NES. So this is a requirement to let all employees know of their minimum entitlements with you. So you can't have conditions in a contract that are less than what these minimum employment conditions are. Employment types and legal distinctions. So one of the distinctions is between employees versus a contractor. So an employee, for example, has a set number of hours that they work, a schedule of hours that they work, and set employment conditions as covered in their employment contractor. They're paid on a regular basis and income is expected usually weekly or fortnightly. Some places have a monthly payroll cycle. Leave accrues, so paid leave is available. Superannuation is paid by the employer and all equipment is usually provided. In the case of a contractor, the contractor needs to register for an ABN and they're paid on provision of an invoice. Work isn't guaranteed beyond the contractor agreement and or completion of the specific work they were engaged for. They don't accumulate any leave accruals. They're responsible for paying their own superannuation and tax. And they need to have business insurance, so for example, public liability and professional indemnity as a minimum usually. A contractor also usually provides their own equipment to carry out the work that they'll be undertaking. So for employees, employment types. So there's a variety of, you could have a full-time employee who's working on an ongoing or permanent basis for a minimum of 38 hours a week. Part-time employees are usually those who work for 35 or less hours a week in an ongoing basis. Casual employees, they're intended usually as a sporadic workforce to cover when usually a full or part-time employee is away, but they are commonly used in some systematic sort of scheduled rosters to cover peak periods. And there's also a fixed or maximum term employee. So that's somebody who you might engage, say, for a 12-month period to backfill an employee who might be on maternity leave or long service leave, just to fill in that gap while there's another human resource taking leave. So a contractor is not considered to be an employee. What are the key documents that you need to provide for an employee? So the first one is an employment contract. So this is a prerequisite to avoid disputes over entitlements. Having the employment contract makes sure the employees are set up properly in payroll with their salary payments and covers most of the entitlements that they're prescribed under the relevant award or enterprise agreement. The next is pre-employment medicals. So a pre-employment or injury medical history declaration. This is a process where a prospective employer signs a form before they're legally engaged. So it protects the employer against the risk of future injury or work cover claims against the company. It also lets the employer know if there's any sort of adjusted work requirements, if they need a certain desk or some other arrangement to keep them comfortable while they're at work. A HR policy handbook. So the HR policy handbook should be provided to all employees. It captures all the HR policies and procedures so that employees know that they need to follow lawful directions and the processes usually that will be undertaken if there's a disciplinary action or other breach that needs to be addressed. And the other process is onboarding. So it's really important that from the first day, the new employee gets a positive experience of the business and familiarisation of the organisation. The first thing that should be done though is making sure that they understand and signed the relevant company policies. So this would be your company's code of conduct, a work health safety policy, IT policy, and make sure that they're onboarded with the different departments of the business, whether this is separate individuals or whether it's the one person doing the whole procedure. Workplace HR policies and procedures. So why are they important? Well, your HR policies ensure the understanding of expectations, and they also support disciplinary or performance management processes. So if you have an employee who has read and understood the code of conduct and has signed that policy document, it can then be used later on down the track if there's a performance that's undesirable. That document can be produced to say, you've stated here that you understand this condition of employment. You understand that if you breach the conditions of this policy, that you may be disciplined and or up to termination. And that starts the conversation, always falling back to the supporting legislation, the supporting document. If you don't have them in place, it's very easy for an employee to say they didn't understand or weren't aware that that expectation was in place. So the key content is about the expectations, grievance and complaints processes, and the consequences of non-compliance. And it's very important to review them regularly. Some of the key HR policies are the Code of Conduct, Recruitment and Selection Policy, Health and Medical Information, Training and Development Policy, which lets employees know the process to request upskilling, particularly if you've undertaken a performance review process and they've identified that they'd like, the direction they want their career to go in. The Information Technology Policy covers off expectations about private use of email, internet or devices during work time. The Grievance and Complaints Policy, that sets up the process so that everyone is aware that if they feel they've been treated unfairly, the process of who to go to and who to speak to make a complaint about that. And of course, the Privacy and Personal Information Policy. The Personal Information Policy is really to be kept in case you need to contact a next of kin or other emergency contact in the case of a medical issue at work. Tax and superannuation requirements. So when you have employees, as a business, you are required to pay tax. So when an employer makes payments to an employee, they need to withhold an amount for payment and send it to the ATO. The amount is dependent on what the salary of the employee is. Reporting income and deductions. An employer is obligated to provide all employees with a group certificate by the 14th of July each year. Generally, these are uploaded and provided straight to the platform at the ATO so that they're there when an employee goes to do their tax at the end of the year. The group certificates from any employees that they've had over the previous 12 months will all be there. And finally, superannuation contributions. The current superannuation rate is 11%, and that's set to increase by 0.5% on the 1st of July 2024, and again next year on the 1st of July 2025 until it reaches the 12%. Payments of superannuation have to be made by employers at least 4 times per year, and this applies from the day an employee starts working for you. Payment due dates are due at least quarterly, as we said. So we've just covered the Fair Work requirements, employment types and legal distinctions, key employment documents, workplace HR policies and procedures, and the tax and superannuation requirements. Do you have any questions for me around those topics?
So thank you very much for that. So employing people is costly exercise. What strategy would you put in place to ensure that you get the right skilled person coming in, whether it's contract or whether it's a phased approach?
So before anyone's engaged, whether it's an employee or a contract, you need to have an idea of what the position is meant to achieve. So for an employee, that would be the development of a position description or job description, which identifies and states down the skill set required, and the key achievables of the role, so that when you're advertising and recruiting to the position, you can put in there that there's selection criteria that the applicants need to address. And then, of course, you go through the shortlisting and interview process and delve deeper into any of those skills. So you need to make sure that the candidate that you want to progress with has all of the skills they need to carry out the requirements of the role, and also that they're a good fit for the organisation. So we have to be mindful that it does need to be a merit-based process, but we are allowed to take consideration for what the organisation's goals and values are to make sure that we have the right employee as well.
Thank you, Mary. I think in terms of choosing the right employment model for your business needs is important, especially short-term versus long-term. But if you choose the contractor path, the first question is, for how long can you keep a contractor on a contractor basis? And what are your options if you reach a certain time frame?
Lena, it used to be a 2-year period, but that has now changed. So you do need to have, it's good if you can set out what sort of project work is in the contractor engagement, so that you can see that they're engaged for a certain body of work to be completed. Otherwise, it can be considered to be a sham contract, where an employer could be just trying to get out of paying their legal obligations in as far as tax, superannuation and work health and safety insurance. But yeah, the 2-year umbrella period, that is no longer in place. And contractors can be engaged with extended contract terms and in sort of a more of an ongoing period in some cases.
In terms of if an employer is needing employees in a short time frame, what are some of the things or the techniques they can use to, I guess, make it first of all attractive, and make sure that there is incentive for them to actually apply and sign in the time frame that is needed? So what levers can the employers use to accelerate the process of signing the letter of offer and onboarding the employees?
Lena, I think the main point is just to keep everything rolling. Sometimes recruitment processes can get a little bit bogged down. So it might be helpful for a business to engage someone like Business Solutions Hub to run that recruitment process for them, to make sure that they're screening the applicants, only sending through the shortlisted candidates that they think are worth interviewing, that have the right skill set, and then also letting them undertake that next step of preparing the employment contract and having them onboarded. Just helps to keep the motivation up. Sometimes businesses get busy running their business, as we know, and if an employee or potential employee is left waiting for too long, they can move on to something else.
And I guess one last question from me is, what are the employer's obligations in terms of provision of documents that by law you need to make available for the employee?
It is important that the documents are covered off, so your bullying and harassment policy, like that HR handbook, it's important that all employees have access to that, whether it's on SharePoint or everyone's provided with a hard copy when they commence, and that they've signed off to say that they've received them and that they understand them.
So, Mary, you mentioned the workplace policies, and there were quite a few examples given, probably between 12 or 14. For a small business that sort of only has about 5 employees, are the workplace policies still relevant? Because it seems like a lot of information to be providing for such a small organisation.
Katie, you're right. And look, the information included in each of those policies can be varied depending on the size of the organisation. So if you do just have a very small consortium of employees, you can still have your HR handbook that states out that these are the conditions of employment that apply to everybody. So while it's better having separate policies for each of those areas, as long as they're covered off and employees have been provided with the information and they've signed off on the information, it is important, say, especially the equal opportunity harassment and bullying, the code of conduct, leave and absences, on your dress and appearance code, they're the main ones, grievance and complaints. So none of them are legislatively required, so it isn't a legal obligation to have them, but they certainly do support the other functions and any sort of questions around applying for leave and entitlement to take leave at the time when it doesn't suit the business. So having those policies actually makes all of the employee management process a lot simpler, a lot more straightforward. Yeah. So if you might try to take a shortcut by not having all of them, but it can end up being a longer way round in the end. And of course, we provide all of those, like we have access to give all of those to the business, like that's a service that we have. And it's always best to have that on board. So you've got them to refer to when anyone asks a question.
It's I'm not sure it's a good question to ask, but how long does it take to dismiss an employee for non-performance? What's the process?
That is a good question. If it is within the minimum employment period, so the probationary period, it doesn't take very long at all. So you just terminate the employment under those conditions of the Fair Work Act 2009. So if that's a small business of 14 or less employees, the probationary period is 12 months. And in businesses larger than that, it is 6 months. So to terminate someone's employment within that period, it's a very straightforward process. The only thing you do need to be mindful of is an adverse action. So if that employee has reported an incident of bullying or they've requested, one of their conditions of employment to be upheld that they don't feel is, if you terminate an employee simply because they've requested something that they are entitled to, they are able to take an adverse action against you. So you need to be careful in that area and get some advice. Other than that, as long as there's a clear process, and again, this is why we fall back to the disciplinary process and procedure and have position descriptions, so that if somebody isn't performing, we have that documentation as evidence to say, this is the requirement of your role, these are the areas you aren't performing in, these are the areas we need to improve. And so there does need to be a process gone through where they're provided the opportunity to improve their performance, but that all needs to be documented, regular meetings, and then if they do fail or are unable to improve their performance, well then they can progress to warnings and first and final warnings, unless of course it is a serious issue of misconduct. And if, say, the Code of Conduct policy says that serious breaches of the policy can and may lead to instant dismissal, you can also invoke that as well. It is a longer time for small business. That legislation's been in place for some time now, though, just to allow small businesses a longer amount of time to assess the person's suitability to fit into the organisation.
As you navigate the complexities of running your small business, we want you to know that we are by your side. At Business Solutions Hub, we offer a dedicated team of HR, workplace relations, and business specialists. Whether you need tailored advice or strategic insights, we're here to assist you every step of the way. If you have any questions or need further assistance, call us on 1300 445 687